As Graham said, this is joint work with Mark Lemley at Stanford. The presentation will be 2/3 as good as the paper, but that's better than if it were just me here instead of both Chris and me. So, and this is really a great paper to be presenting to this sort of interdisciplinary group. So the paper is all about the various types of intellectual property protections that are available to designers of all different sorts. Designers of clothing, designers of automobiles, or other types of technology, and everything in between. And the idea behind the paper is that there are a wide range of different types of intellectual property protections available. There are copyrights for certain types of designs, there are design patents, there are utility patents, which are meant to cover functional elements, but can also be sort of used for pieces that relate to design as well. There are, of course, trademarks and other things like that. All of these different types of intellectual property protection come with different advantages and disadvantages for the designer. And therefore for society at large. And of course, this is appropriate in part because there are many different types of design, and different designers need different types of IP in order to accurately and appropriately protect their designs. Now, the issue for us, and our jumping off point, is that what's good for the designer is not necessarily always good for society at large. So the point of these intellectual property regimes is to provide designers with incentives to produce more and better designs, allowing them to protect those designs so that they're not pirated after the fact. However, if the design protection is too strong, it might allow the designer to gain too much power over the design, squeeze out subsequent designers, raise prices too high for consumers. If the design right is too weak, it might not be enough to encourage the designer to actually create the design in the first place. And so we want to try to balance these things. And as I said, what's good for the designer is not always best for society. So a very, very powerful design right would certainly be good for that particular person who's creating the design, but it might not be as good for the rest of us. Okay, so here's what we're going to argue. We're going to argue that intellectual property law uses a variety of different screens to try to sort designers into the right intellectual property type of protection, the right box, as it were. And what we mean by screens are just doctrines or other sorts of procedural mechanisms that make it more or less easy or more or less costly to try to claim a particular type of design. So a doctrinal screen, that's just our fancy name for law, basically. The law is going to sort people into different buckets. A costly screen, that's just our fancy name for having to pay a bunch of money. So sometimes the law will require you to pay some amount of money if you want to opt into one type of IP protection or another, and that will cause designers to want to sort themselves. The second part of the thesis, which Chris is really going to get to more, is that these screens have broken down, and that if the system was ever functioning properly, it's not anymore because of some new changes in the law and some new changes in how the various institutions that manage intellectual property have been functioning lately. And so we're going to try to talk about what we think of as the breakdown in these screens and how they could be improved. Okay. All right, so to sort of motivate all of this, I want you to try to, as I said again, sort of separate again in your mind what the value of a particular intellectual property right is to the designer and what the value is to the rest of us. So the value to the designer, we're going to call that private value. How much value is there to a particular designer when that designer owns a design right, be it a copyright or a design patent? There might be some design patents that are incredibly valuable, and some copyrights that are incredibly valuable to the individuals who possess them. Chris will talk about some examples. There might be some that are not very valuable to the individual who possesses them. So we talk about these as high private value and low private value sorts of design rights. So that's the left-hand column here. A design right can either have very high private value, meaning it's very valuable to the person who owns it, or it can have much lower value. But separate from that, on a completely separate dimension, there is the issue of whether that design right was valuable to society at large. So on the one hand, we want people to be rewarded for new and innovative and valuable designs. We want them to get design rights that allow them to collect revenue. So society is happy when someone creates something that's new and valuable and they get an appropriately powerful design right to protect it. On the other hand, as I said, if that design right can be too powerful, it might impede future designers. We worry that someone will be able to lock up a whole field of design or of technology by virtue of hanging on to that design right. Or if it's too weak, they might not have the incentives to create in the first place. It can also just impose costs on consumers. We pay more for things that are protected by copyrights or by design patents than we do for goods that are not, simply because somebody controls that good with that intellectual property protection. So as a society, we want things that have positive social value, where we're happy that the person created the design and the intellectual property right that they have over it is not too powerful. So sorry, so this is the left column, like I said. So we want design rights to be created that fall into these two boxes of positive social value and not these two boxes of negative social value. But of course, the designers want things that fall into these two boxes of high private value. Excuse me, the top row is what I should have said earlier. These two boxes of high private value and not these two boxes of low private value. So the trick is to get law to sort design rights between those various boxes. And there are a number of mechanisms for this. Okay, so the most obvious way is to just use law. Use a doctrinal screen that tells you sort of which type of right you should have, which type of box you should be in. And so law has a number of different mechanisms to sort people as between design patents and copyright. Sometimes you can obtain one and sometimes the other. And then even within design patents and copyright, when you're allowed to get a copyright and when you are not, when you're allowed to get a design patent, when you're not. The main ones that they use are creativity thresholds. So you don't have to be all that creative, you don't have to do anything too terribly new to be able to obtain a copyright. The threshold for a design patent is much higher. You really have to do something that's new and not obvious compared with what came before it. And there are also functionality limitations. This is a way of sorting people based on how functional their design is. So it's one thing if you're just doing something that's purely ornamental or aesthetic, but a lot of designs incorporate some element of functionality to it. So just to take one example that we talk about in the paper, think about a design on a life preserver. You know, partly a life preserver might be designed, you know, you might pick the yellow color, let's say, for aesthetic or ornamental reasons, but the shape of a life preserver is also defined to some extent by the shape of the person who's going to be wearing it. And so there's an aspect of it that's functional. So we want people to be able to control the ornamental part of that design, the color, the whatever sort of aesthetic addition they might have made to that life preserver. But if they can control the functional aspects of it as well, that will make it even much more powerful. So copyright and design patents both in theory had a strong sort of limitation on capturing the functional elements of designs. Copyright, it was strictly prohibited to copyright anything that had a functional element to it. Design patent was a little bit more permissive and used to permit patents on designs that had some functional elements and some ornamental elements. Okay, so these are the main sorts of doctrinal screens, the main forms of law that we would use. And so here's sort of what they look like. So in theory, if these doctrinal screens were working properly, if the law were functioning perfectly, they would draw us sort of a bright line between those design rights that are positive social value, where we think that, hey, it's good that you created this design, and we're happy to incentivize it, and you're not getting more protection than you should be entitled to, and block off the things that have sort of lower value, lower social value, or negative social value, which is on the right side. But of course, law is not perfect like that. Law is mistake prone, and it's hard to really capture in just a few legal doctrines to be implemented by courts everything that we want to capture about what makes something valuable to society versus not valuable to society. These screens that we talked about, the creativity and functionality screen, those are just rough proxies. So in all likelihood, there will be things that are negative social value that will slip through. Designs that have too much functionality incorporated into them. Or designs that are just simply not creative enough, where we're giving someone a copyright or a design patent when they haven't necessarily done enough new work to be entitled to one. Okay, so what's the response to that? So the response to that is to use a costly screen in addition. So in order to deter people from going out and capturing lots and lots of low private value copyrights or design patents. So just, let's just try to copyright everything in sight, or let's just file for design patents on every single possible iteration of this design that we can imagine. The law imposes some actual monetary costs. So before you file for a design patent, you have to pay fees to the Patent and Trademark Office. And you often have to hire a lawyer who will cost additional money as well. So design patents include real costly screens. Although copyrights generally do not. Getting a copyright is essentially costless and instantaneous. But the point that we want to make about these costly screens is that they're always second best because they don't sort things based on how socially valuable they are. They only sort them based on how privately valuable they are. If you have to pay some money to get an intellectual property right, the thing you'll be thinking about is whether the amount of money that you have to pay is more or less than that intellectual property right is worth to you. So you'll be thinking about private value rather than social value. So these costly screens, they're going to sort as between high private value and low private value inventions, not high private value, not high social value, low social value inventions, the way that law tries to at least. Okay, so this is what this looks like. So whereas law draws a sort of squiggly line between positive and negative social value, costly screens draw this line, usually a brighter line, between high and low private value. So this is both good and bad. On the one hand, they are excluding these things that are in this quadrant, low social value or negative social value, low private value types of intellectual property rights. But they have this other sort of negative effect of excluding things that might fall into this box. Low private value, but high social value types of rights. And those we would like to have. So we only want to deploy the costly screen when we think that the things in this lower box here will actually be relatively few in number, that we won't be losing too much by putting the screen in place. And when we think that the things in this box will actually be very large or numerous, and that we'll be blocking out a lot of potential low private value, negative social value types of intellectual property rights. So that is our basic framework. This is the idea, is to think about how law can use both doctrinal measures to try to separate positive and negative social value, and then also these sorts of costly measures that interact with private value, so that we just end up with the types of design rights that will be socially productive and that we think will be sort of useful both for the designers who obtain them and for society at large. Okay, and at this point, I'm going to turn it over to Chris.
Thanks, Jonathan, and thanks again for welcoming us out here. This is a really wonderful opportunity. Thanks for coming to the talk. As Jonathan explained, the kind of background theory that we've established for the paper, it turns out, we argue, that either intentionally or accidentally, Congress and the courts had basically been getting it right for much of the 20th century. Right, so that the set of regimes and doctrines and screens that the Copyright Act and the Design Patent Acts had produced were basically doing the thing that we wanted them to do. And so let me just kind of explain basically how that goes. Right, so if you think about copyright, like as Jonathan has already explained, copyright applies a relatively low creativity threshold, one that is virtually zero. Right, like alphabetical organization of the white pages doesn't make it, but the organization of the yellow pages does. Right, so a very low creativity threshold coupled with an incredibly low costly screen. But it balances that with what was, at the time, a substantial functionality bar. Right, so if you were going to attempt to use the low creativity threshold to think, hey, look, I don't have to be that clever. I can just get all of the rights via copyright very cheaply. Right, what copyright law said was, no, you can't. Not when you're attempting to mix in your creativity with some substantial amount of functionality. Right, so the substantial functionality bar in the useful articles doctrine basically was kicking out a lot of stuff out of copyright law. You had to look somewhere else for protection. Right, so where did you look? Right, so I'll just explain basically how this worked in copyright law. Right, so and this is key to understanding the functionality claim in the paper. Copyright law has always been, until very recently, hostile to certain kinds of functionality in design. Right? So on the one hand, you are allowed to copyright things like this, things that are purely non-functional. The hood ornament on the front of the Jaguar plays no functional role for the Jaguar whatsoever, and copyright was appropriate. Copyright always kicked out, and still kicks out things like this. Does anyone know what this is? Yeah, it's a timing belt, right? So this is the Jaguar timing belt, right? So no aspects of the timing belt have any aesthetic considerations in them whatsoever, right? This is meant purely to serve a functional purpose, right? It doesn't matter how it looks. No one's ever purchased a timing belt for how it looks, right? So these always have been and always are excluded from copyright. But the challenge has always been thinking about stuff like this, right? The shape of the hood of the Jaguar. the E-Class, the most beautiful creation made by humanity. Right? So the thing about the Jaguar, right, is that the hood is simultaneously the most beautiful thing ever made by humanity, but also partially functional, right? It affects the aerodynamics of the car, it affects the speed of the car, it affects the gas mileage of the car, right? So copyright's rule has always been basically to kick all of this stuff out, to isolate only, right, the purely non-functional for copyright's regime. This is what the functionality bar has long done. If you wanted to protect this sort of stuff, you had to go to patent law, right? In particular, design patent law, right? Because this is what design patent law did. Unlike copyright law, design patent law applies a much looser approach to functionality screening. Design patent law has always tolerated some degree of functionality in the nature of the claims that you could bring. Right? So these sorts of dual nature, hybrid features were always the appropriate province of design patent law. But this started to look scary, right? So if now people can protect functionality, stuff that has some important market power associated with it, the law basically said, let's make sure that people are doing something really valuable. And so it did that by imposing a substantially higher doctrinal screen. Right? So now what you have to do in order to get a design patent, in theory, is these are various cases that you may have seen, we can talk about them later on, right, where functionality was allowed in shoe design, functionality was allowed in this tool design. But design patent law said, if you're going to get a right, you've got to be pretty creative, at least on the books. Right? So on the books, design patent law requires the same thing that utility patent law does. That a design be novel, never existed before, and non-obvious. Clever designers would not have easily thought of this. And presumably it imposed some substantial ex-ante screening. It cost some money to file for a design patent, unlike no copyright. Right, so these were the sorts of things that were supposed to be eliminating, channeling our approach to design. And it was basically going to look like this, right? And so you can imagine this world, right, where copyright protects aesthetic features if original, design patent law protects them if they're novel and non-obvious, right? And we get, these kind of additional distinctions about duration, which is very long for copyright. It's got other sorts of limitations in the fair use doctrine and the damages apportionment, design patent, shorter duration, different damages provisions. But this is basically the world that existed before 2 years ago or something kind of like this, right? And our argument is that now all of this none of this is working anymore, right? And this isn't working anymore for a couple of reasons. In part because copyright law is not doing the functionality screening that it used to be doing. Copyright law, after the Star Athletica opinion, right, this came out from the Supreme Court last year involving these incredibly beautiful cheerleading uniforms, right, basically said, well, we don't care so much about functionality, right? The strong bar against dual nature features in copyright law is no more. Exactly what's going to replace it is a little uncertain. We can talk about exactly what's going to replace it. But the big difference here, I think basically most people who've read the opinion agree, that the law has become much more tolerant of functionality in copyright law than it used to be. Right? So now copyright law will tolerate functionality in a way that it didn't. In addition, design patent law's ostensibly high creativity thresholds, novelty and non-obvious, are virtually meaningless. Right? The PTO only invalidates about 2% of its applications because of a lack of novelty or non-obviousness, and it's really hard to establish them. So like things like rounded corners on a tablet easily clear the novel and non-obviousness bar, right? Because there was nothing precisely like that in the prior art that clears the novelty and non-obvious bar. So does this, right? This is wood, right? Or at least a picture of wood, right? This is a wood tile, right? So it looks like wood, right? And the PTO's like, yeah, sure, good enough, right? Because there's not exactly that pattern of wood somewhere in the prior art. You can claim that pattern of wood, right? So the ostensibly high creativity thresholds in design patent law aren't doing any work. In addition, design patents are basic. They're close to free. Right? So although they are supposed to be costly in the way that utility patents are costly, they tend not to be. Right? It only costs about $5,000 in total fees. That includes attorney's fees and drafting fees. Right? This is like a rounding error for for Apple. Right? This is like just not serious amounts of money in many respects. Right? And pretty inexpensive for purposes of their ability to buy lottery tickets for design patents. And then simultaneously, trade dress law is making all of this worse potentially. right? Because it's allowing us to have this kind of interweaving protection outside of the kind of IP channeling between utility patents, design patents, and copyrights. Trade dress law is allowing in its own separate kinds of claims, different sorts of issues with functionality and claiming, but again, kind of complicating the world, allowing people to select among lots and lots of rights. So we think things are pretty bad after Star Athletica. They're not quite so bad, in part because design patent law is also terrible. Right, so so at least in a world where copyright is weaker, that matters a little less because design patent law is also super weak, and at least in some cases the differences in duration are not that significant. Copyright also has these other doctrines that can be important in terms of fair use and independent invention that we can discuss as well. But it's still really bad. You see now these kind of overlapping legal rights. Right? So the one thing that we now have, at least in the last quarter of the 20th century and on, is the opportunity for designers to get all of the possible rights. So this is a case in which the creators of this, like, what is this? A seal or an otter?
A walrus.
A walrus? That's a walrus? A walrus? Right. Jonathan goes to the zoo a lot more than I do. It also, you read the patents. Jonathan also reads patents. Jonathan teaches patent law and just reads patents. I don't know what
You look at the pictures.
Right. Yeah. So here you've got a walrus plush toy, which is covered by a design patent. Is also in this case asserting a copyright. Right, and if this were brought to you by Thai Beanie Babies, right, they'd also be asserting a trade dress, right? And so here they're able to basically bring all of the potential claims simultaneously and kind of pick and choose the doctrines that they like when they need to, the scope claims, the liability claims, the damages claims, right, the independent invention ones, right? So for all of these reasons, we're pretty nervous. So what can be done? We've got a bunch of different potential moves at the end of the paper that we think people could make, and various people, sometimes Congress, sometimes the courts, sometimes the PTO, that might begin to solve some of these problems. And we're just going to kind of put a few up on the board and we can kind of talk about them later on. Obviously, Congress could attempt to fix Star Athletica. There are more important things for Congress to not do, we suspect, than to fix Star Athletica, so we're not especially sanguine that they're going to do this. But right, they could. Nonetheless, we think district courts could play some role here, right? Doing some stuff more with merger, limiting scope on infringement claims, maybe importing fair use doctrines. I'm skeptical they're going to, because I don't think they have incentives to be gatekeepers, but they might, and it'd be nice if they did. We could fix design patents in a bunch of ways. Courts could impose the creativity thresholds that are actually written into the statute. They could shore up some aspects of patent law's functionality screen, which has been getting weaker over the last decade or so. Congress could create an independent invention doctrine, like copyright law does, and that might have some important role. So if two designers hit on the same shape for a clicker at the same time, in part because of the natural limitations of the human hand, right, then the second designer wouldn't be subject to infringement of the first designer, which is the role that copyright currently has long had. In addition, and this is important, we think, the PTO could just raise fees for design patents. And as we explained in the paper, if the PTO did this and just lit the money on fire, that would be good, right? Because it would screen out all of those low private value, negative social value design patents. Right, so if that's all they did was just charge the money and just throw it in the river, right, that would be good in and of itself. In addition, we'd rather them not do that, right? In addition, they could then spend that money on actual examination, right? They could go into the archives and figure out, yeah, we actually already know what wood looks like, and so you don't get a design patent on wood, right? They could spend the time and money that we've shown, that others have shown matters for utility patent examination on design patent examination, and so they'd start to kick out a bunch of design patents that are, again, low social value design patents. So the opportunity to raise money at the PTO could be enormously important. So we're in favor of, if all of the doctrinal screens don't work, substantially increased costly screen in this case. So this is basically the set of solutions. Finally, one thing Congress or the courts could do is bring back a doctrine of election. If you're going to assert trade dress rights, you can't also claim copyrights. If you're going to assert design patent rights, you can't also claim copyrights. If you're going to claim copyrights, you can't assert design patent rights. Right? So you only get one bite at the apple. This is more or less the way the world looked back prior to the 1970s. It could come back. We think that this is a better world as well than the one we currently have. And we're happy to talk about the various ways in which that might arise. But thank you. We'll take questions. Jonathan also thanks you, but he didn't in the front slide. Mark probably also thanks you.